another.
Yes.
My lord, my lady, His Lord Lord Justice Green asked a question yesterday. We said we'd get back to him, and we thought it best just to interpose briefly to
Okay.
Provide the answer.
Remind us what the question was.
His Lord Lord Justice Green asked whether it was possible to compel third parties to honour travel cards, by which we understood, in effect, compel them to sell boundary fares or their equivalents. And my instructions are as follows: that the contractual and the contractual position between my client and third parties and the regulatory position is extremely complex. And that is not least because of the fact that there are numerous licensees with different third-party contracts. The outcome of that is that we consider that paragraph 28 of Mr. Cameron's statement is incomplete, and therefore reliance should not, we accept, be placed on it. There is also the question, of course, of the contractual rights of other train operating companies, which adds to the complexity. Now, if it would assist the court, we could do our best to provide a summary of the position to the best of our ability, but I am told it is both complex and unclear, and it will take some time to unravel and to get to the bottom of it, even within a few days. Now, it may be that the issue is no longer relevant, and this is all a bit of a sideshow, but we're very much in your lordship's hands.
I think the question, maybe I reframed the question, because in my own mind it was whether train operators were prohibited regulatorily from requiring third parties to honour travel cards.
Ah, I see.
Which is perhaps another way of putting the point you've just asked, because
yes,
you can do anything by contract. It may be complex, it may be very simple.
Yes.
The question is,
so is there a
regulatory prohibition
yes.
on the train operator from saying to third parties, you must honour travel cards?
That of course itself might be
it may be
a very complex, which may admit of no easy answer. I mean, for example, it might be, of course, that the third party might themselves object to any attempt to do so on competition law grounds, for example. But it's hard to anticipate. Would it assist if we did our best to answer that in writing?
Should we review it at the end? We'll review it at the end of the hearing.
I'm grateful.
Rather than putting you and your clients to refer the burden of trying to answer a complex question which might take days to answer.
We're grateful.
Yes.
Thank you.
Mr. Moser.
My lady, my lords, again, I make the traditional start with something I've been told I've missed. On the first day, I told the court that we did rely on the travel card agreements for something, but I never told the court what that thing was. In fact, in the CAT, we relied on the travel card agreements for two things. The first, which doesn't matter very much, but the first was that under these travel card agreements, the TOCs are entitled to the revenue for the part of the journey covered by the travel card. And that's picked up in the CAT's judgment at paragraphs 16 and 32. Arguably greater stress, perhaps, was laid below on the fact that the travel card agreements used, guess what, a survey for calculating the revenue for the travel card section. And we addressed that in our skeleton below, which is in Supplementary Bundle 2, tab 16 at page 575. At 575 little c, further implicit criticism, the claim we need to rely on a proxy to estimate travel card holdings is also misplaced. It is a normal feature of competition damages claims, particularly collective proceedings, combining a large number of individual consumer claims that the courts are required to do their best with the evidence available, Merricks. Further, and in any event, the fact that the TOCs themselves use survey data and extrapolation from travel patterns to estimate the journeys made by travel card holders on their services for the purpose of revenue apportionment demonstrates the number of in-scope journeys in these proceedings is a matter capable of being estimated in a similar fashion. And that is the short point. I know the court has the travel card agreements. I don't propose to delve into them. The original 1995 agreement relied entirely on surveys for all apportionment. From early 2017, that was changed because data is now held on Oyster cards. But a survey remained for something called an out-boundary travel card. An out-boundary travel card, at least until it was all suspended for COVID. And just to note, if somebody does want to look at it, in the 1995 agreement, survey is defined on page 26 and then explained in Schedule 4 at pages 58 and following. And the equivalent Schedule 4 in the 2018 agreement starts at page 87. And that is all I want to say about the travel card agreements.
And just so your opponents are aware of where that came from for me, I tried to get my head around the apportionment formula, which, as you will know, is quite complicated. Yes. But I deduced from it that there had to be some correlation between use of card and in-scope journey in order to calculate the apportionment. And I was therefore surprised at the submission that there was no data available from within the defendants which enabled that to be calculated. Because I rather assumed that at least some of that data was available for the operation of the apportionment and settlement formulae in the travel card agreement. And you said at least, so that I think is really encapsulated within both of your points.
Yes, my lord, save that from recollection what was said below is, yes, that data was available at the time if you took the survey within X months or years, but then is no longer kept. That's I think what the argument was.
My lord, I think there is a risk of some confusion here. There is no data, and it's completely common ground that there's no data on the relevant overlap. That is to say, who took a potentially relevant in-scope journey, a journey going out of London, and where that journey overlaps with somebody who has a travel card. That is completely common ground, and Mr Moser made the point, his exact submission yesterday was, it is common ground that there is no such data. Mr Holt accepts that, that's why he has to use
How does the apportionment formula operate?
Well, that is a complicated matter.
Isn't it
but what
designed to get to that
I think the
very
critical point is you don't have to record the name or personal data of anybody.
Understood.
Right, so that means you can't
It's an
then
aggregated
match.
process.
I beg your pardon?
It's an aggregated process.
Well, it's a different process, my lord, because all you're concerned to do is you're not concerned when you're asking yourself whether a journey has been carried out with a travel card, with who the person is who has carried out the journey. That is simply not recorded, and it doesn't need to be in order to apportion the revenue. And that's wherein lies the problem.
Okay, thank you.
My lord, yes. I mean, everything Mr. Harris says is accepted in the sense that we don't know any better at this stage. We are at an early point in this, as we've heard from both my learned friends in their very different interventions this morning. As soon as you scratch very slightly the surface of any part of these arrangements, it gets very complicated in a way that we say will be fit for and have to be dealt with at trial, not finally decided or completely explored or explorable at the certification stage, when we haven't even had any disclosure beyond the basic numbers of boundary fares sold and overall fares sold. Mm-hmm. So that brings me to what my learned friend Mr Harris called the 7 scenarios, which is what I plan to spend most of the rest of my time today on. I will come very briefly at the end to one of the strikeout points and the other point made by Mr Zhao. In fact, there are more than 7 scenarios in a sense, because Southeastern put forward 7 scenarios at paragraph 42 of its skeleton, and Southwestern put forward 6, but largely overlapping ones at paragraph 45. Mr Jowl then added one on his feet. These scenarios all reflect and repeat submissions that were made before the tribunal, and they are addressed in the judgment of the tribunal at paragraphs 126 to 134. All of these scenarios are meant to be examples of situations in which a passenger would not have bought a boundary fare, it is said, even in the counterfactual. And my learned friends are tempting this court to look again at these evidential points from below, at times taken from the witness statements rather than the judgment, and to take a different view from that taken by the cat. The court has my submissions as to why that is not the function of this court, and I won't repeat the legal points. Just a side remark, my learned friend Mr Harris repeatedly calls this the uncontradicted evidence or similar. I repeat that it is only evidence at the certification stage. We haven't had disclosure yet, and anyway only uncontradicted up to a point. So for instance, where Mr Backway and Mr Cameron consider in their view that these scenarios present insuperable obstacles to certification, Mr Holt, in his second report and in his oral evidence, disagreed. The tribunal didn't finally decide any of these points, but quite reasonably found that these are matters for trial. And in case of the strikeout points, more than merely arguable matters for trial. For the purposes of this appeal, the question is not whether these scenarios are right. Rather, the question for this court, I suggest, is as follows. Whether the tribunal could reasonably come to the conclusion that the class representative's methodology could deal with these scenarios at trial, if that should become necessary. Then there is the further point made on advance fares, where there's the additional question asked by my learned friend Mr Harris, but not by my learned friend Mr Jowl, as to whether they should be so obviously excluded at this stage. It will be recalled he asked why not? Whether they should be so obviously excluded that the tribunal should have just struck them out altogether. I'll deal with that point separately. But on the 7 or whatever it is scenarios, we identify 3 categories of scenarios broadly. The first is scenarios that can in fact be addressed through an adjustment to the class definition. And that is classically that if a whole ticket type is said to be excludable, such as advance fares, if they were right about that, those could, if needed, be excluded entirely from the class definition and therefore the loss calculation without the need for any estimates or similar. And it will be recalled the class definition doesn't have to be fixed at the certification stage. The reason for this is that Mr Holt's methodology calculates a loss for any non-boundary fare tickets sold, which is then multiplied by the estimated share of those tickets used by a travel card holder. Once we have disclosure of actual tickets sold, all purchases of, for example, advance fares could simply and easily be excluded, because that data must be available. I think it's common ground that that exists. The class definition would then say any passenger who purchased a fare that was not a boundary fare or an advance fare. And so that is the first scenario where, although we say it's not necessary, should it become necessary, easily excludable. I point out for the avoidance of doubt, that's different for the point-to-point fare exclusion, which in the way that it's used in this case isn't a fare type. The tribunal, of course, has already ordered the exclusion of our point-to-point fares, and I'll come back to that shortly. There's a second set of scenarios, in particular on my learned friend Mr Jowell's case, which assume, we say, irrational or non-price optimizing behaviour by a class member, generally in a situation where boundary fare was available, was the best fare, but for some reason the class member still didn't purchase one. That's the one where in our submission we are entitled to rely on the assumption that the overwhelming majority of passengers would not choose to pay more for a train journey if offered the opportunity to buy a cheaper ticket. And the tribunal found and was entitled reasonably to find that they could accept such a proposition. And one specific
And of course, that issue is to be assessed, isn't it, by reference to what, on your case, should have been the position in terms of the availability and publicity of boundary fares. There's no use saying, well, if you had to kind of rootle around on the internet or rootle around or go and ask 5 people in the station, nobody's going to do it. Because the whole essence of your case is if this thing was set up properly, so that it was all very straightforward. So, for example, if you're looking at it on the internet, you just click on a button, it gives you a series of options. Then you say, well, you know, who's not going to do that?
Well, my lord, yes, and that's exactly the answer to my learned friend's point. Well, what if I'm in a hurry? In the counterfactual, where a boundary fare is readily available as, say, an off-peak fare, that whole scenario falls away, because even in a hurry, a passenger needs to buy a ticket. And if I'm rushing for a train, I would still buy an off-peak ticket, which I know about. I wouldn't suddenly buy a peak ticket just because I'm in a hurry. And in the counterfactual, where boundary fares are as available and as well known as off-peak tickets, that's what would happen. So
Most TVMs where you do have that option, it doesn't say when you put in, have you got a travel card, and you say yes, it just gives you a price. It doesn't say, would you like to pay this price, or would you like to pay £5 more? Not a question of option, they just give you the price. It is the price. It's not an optional price, pay more or less.
So there's no choice there.
There's no choice.
No.
Other than the choice to click or not click.
Yes.
yes, well, but is your lordship's point that there would be an extra screen?
Well, I mean, some of the case law, the European Court case law wasn't about choice. It was about the obligation of the dominant undertaking simply to apply the prepaid discount and then come up with a single end price. Not, as I think this litigation is the way this litigation is framed going forward, that there was a duty to provide a choice. But I mean,
There is a duty to provide the correct price for the journey.
Yeah.
It's not that. The thing is, it's not really a choice. Yes, you can portray it as well. You've got a choice. Would you like to pay £50 or £100? Oh, I don't know. But it's not really a choice because the vast majority of consumers, apart from completely irrational consumers, are going to go for the £50. So if you've got a button that says, "Have you got a card?" and you press it, and you're told you can therefore get a ticket that's £7.50 cheaper. That's
I suppose it's slightly more complex in this sense. that if you're going to do it, you're going to set up an automated system. You'd need to ask the question, do you have a travel card? And then you'd have to say yes and then identify which zones it was for.
Sure.
But once you've done that, on my lord's example, as with any other rail card, you'd be given an automatic price, which is a discounted price,
Yes.
which included the boundary fare.
yes, exactly.
So you're not being charged, as it were, 2 separate fares. It just reduces the total you've got to pay between Richmond and Southampton Airport, in the example we were given.
My lord, yes, and so it's not very different from the rail card example, or the senior rail card, or the student rail card, where there is an extra step, and you say, yes, I've got a rail card, and then you're given the price.
Yeah.
The duty of the dominant undertaking is to make that available to the consumer, not to conceal it in the way that we've described. So what's going to happen is not so much that the machine is going to offer a choice. The machine is going to ask the consumer a question, and then we tell the consumer the correct price. That's the nub of it. It's not for the burden ought not to be on the consumer to have to work out. Well, I could perhaps mitigate if I bought a ticket from Clapham Junction to Brighton or whatever it is, or well, I think I might be able to find some other version of this if I delve deeper into the ticketing options. Of course, we know it's not there in most of the cases, but say it were. The duty on the dominant undertaking is simply not to double charge its customers, and that onus is on them, not on my class members.
And that, I think, is, as I understand, I mean, there was some debate about this in the context of the argument about strict liability in front of the CAT, whether this was strict liability, but the CAT then cited Deutsche Post and DSD, and the paragraphs from Deutsche Post that they cited, paragraph 61 in particular, which is paragraph 56 of the judgment, involves the CAT saying it's an abuse to demand the full price. And the bit that they quote from paragraph 61 of the judgment is it's an abuse for Deutsche Post to charge without deducting. In other words, the price you offer is the reduced price. It's not an option. Yeah. Would you like to pay the full price or the reduced price? It is the deducted price. It's the end result.
Yes, exactly, my lord. It was an abuse for them to demand the full internal postal rate where they recovered the terminal dues, i.e. the difference. Yep. And the CAT then also went on to say that not only is there that established form of abuse, but there is also an emerging form of case law, including in Germany and in this country, of unfair selling systems, unfair trading conditions under the Chapter 2 prohibition. And then it goes on to cite Preventex and Facebook in paragraph 60 and 61 of the judgment below. And that is another potential way of looking at the same thing, which is to say the categories of abuse are not closed. Conduct may constitute an abuse where it consists in directly or indirectly imposing unfair purchase or selling prices or other unfair trading conditions. And that whole ecosystem of ticket purchasing through machines online at windows, that system, which is the same for everybody, we say, is also an unfair trading condition.
You don't have Facebook, I think, in the authorities bundle. I was trying to, what did you have in front of the CAT? Is it possible that we could be provided with whatever the CAT had?
We can seek to, yes, we can provide your lordship with a copy of Facebook. I don't think the CAT had Facebook before it. I think it was mentioned
It's
from
mentioned in
the
Preventex,
bench.
I think. That's where it comes in. I think
That's-
you look at
that's
60 and
probably right.
61.
Yes.
It says in 61 they say, the court there also referred to the recent decision of the German
Facebook. I'll just check with my juniors. We checked. We don't think it was before the CAT, but the President was familiar with it from the other case, which was also his own judgment.
There presumably is some English translation of it somewhere. Can we leave that with you?
Yes.
Anyhow, I mean, the bottom line is the tribunals said that these are matters of arguability to be thrashed out at trial, which included the scope and effect of Section 18 as it applies. So the matters we've been debated are really assuming, which depends on our judgment, this goes ahead, then this will be thrashed out at trial.
Indeed. And we also say that this argument about whether there might be somebody who didn't act rationally, who inexplicably bought a more expensive ticket or whatever, we say two things. We say first, that would be a very small percentage of people for obvious reasons. And the second, that could be addressed via an aggregate adjustment, a discount by statistical means. And if I may say so, that would also be a much more proportionate way of addressing it than, for instance, the alternative of a test case that Mr Harris now proposes as his fallback position instead of 3 million individual trials. So that's the second kind of scenario. The third kind of scenario is actually in much the same vein, and indeed overlaps to some extent, which are scenarios likely to be de minimis in scope, and therefore also clearly susceptible to class-wide adjustment at the end. Apart from, as I say, passengers buying the wrong ticket by mistake, we say this would include people who've forgotten their travel card at home. This is all assuming that the tribunal found it necessary to adjust at all for these things. Now, in Mr Harris's second alternative, as he calls it, so that's assuming that there's no absolute requirement to weed out all non-injured claimants, class members. In his second alternative, he accepts, I think, that a class-wide adjustment may in principle be an appropriate way of dealing with such issues. The criticism has shifted in that respect to say, well, no attempt has been made to estimate such an adjustment, and I quote, "It is manifestly insufficient to meet the Microsoft test, which requires a clear articulation of a plausible methodology by which the size of such a class-wide reduction could be calculated," unquote. But I say this overstates the test. Microsoft requires only that the methodology must offer a realistic prospect of establishing loss on a class-wide basis, what I called the low bar yesterday. So there is a danger of over-reading Microsoft. There's also a danger with respect of reading Microsoft too much like a statute. It is an accepted test, but it is still subject to the court's interpretation of it. And matters about the detailed specification of the expert models are matters for trial. And it's simply premature to entertain detailed criticisms about model specification at the certification stage, as the CAT found. And this is what this is. This is a detailed criticism. These are all criticisms, although they obviously were put forward eloquently yesterday morning and at length, but we're dealing with the extreme end of the more obscure scenarios. And instead, for an example of the correct approach, I cited the approach taken in Consumers Association and Qualcomm yesterday. And Mr. Holt indicated in his evidence that most of these scenarios are either susceptible to being quantified by his methodology and with the help of a survey, or by reference to some comparison, such as the extent to which off-peak travellers buy off-peak tickets. So as briskly as I can, having given them an indication of the sort of things I plan to say about all of these scenarios, as briskly as I can, I'd like to address the scenarios in detail. The 7 scenarios as advanced by Southeastern, at least in their skeleton argument, I'll try to be as comprehensive as I can by dealing with the skeleton and the submissions. Southeastern says, well, an advance fare may be the same price or it may be cheaper. But with respect, that misunderstands our claim, which argues that boundary fares should have been available for all ticket types, including advance tickets. And obviously that overlaps with my learned friend's, Mr. Harris's strikeout point. But provided we are arguing over advance tickets, that is a complete answer, if we're right. If that is decided against me at trial, then as I've said, advance tickets can simply and cleanly be excluded. So this isn't an example of a struggling methodology at all. This is really just Mr. Harris disagreeing further with advance tickets being decided at trial. The tribunal decided this question should be decided at trial. We have addressed this point in section G of our skeleton argument at paragraphs 85 to 90. I can perhaps conveniently address the strikeout point made by South East but not South West on this issue here as well.
Can I just ask you, if you lose a trial on this, what does the CAT exclude? Is it people from the class, those who only buy advance, or is it just really a matter of quantum? What's the adjustment made? To what, as opposed to the detail of it? Or is that really, is that also speculation?
Well, it's speculation to a point, but I'd suggest it would be an adjustment to people in the class. So you'd exclude people who bought boundary fares, or people who bought, or people who bought advance fares. My learned friend then went further and he said, oh, well, actually, this whole thing ought to have been struck out by the tribunal. So he's alleging there's not even a more than merely arguable case on our argument that there should be boundary fares for advance fares. And his appeal point is that he was misunderstood by the tribunal. Can I ask the court please to turn up paragraph 74 of the judgment, which is the point that which is the paragraph my learned friend attacks with this point. At paragraph 74 then, the tribunal says, in our view, a boundary fare should not properly be regarded as a discount. So that's a disagreement with the way the other side puts it. We agree. It is more appropriately viewed as the fare for the part of a journey not already paid for and covered by a travel card. But the thrust of this aspect of the claim appears to be that the applicant contends that where a discounted fare is offered, a similarly discounted boundary fare should be made available. As I understand it, my learned friend takes issue with this characterization of our case by the tribunal. But I don't see the problem. It's certainly on his case that an advance fare is a discounted fare. So it's quite right that what we're saying is that where a discounted fare, in this case an advance fare, we don't necessarily accept it's a discounted fare, but where an advance fare, discounted fare is offered, on his case, a similarly discounted boundary fare should be made available. And there's then further discussion that the applicant recognises some promotion, I've skipped a bit, that some promotional fares may be so discounted that having a special boundary fare in those instances may not be proportionate. So kids for a quid, for instance, that's quite right.
But the way it works is this, isn't it? I mean, let's take that example of the journey between Richmond and Southampton Airport, and you've got a travel card that covers you to the edge of Zone 6, so I can't remember exactly where that is, but it certainly will go out some way towards to the south. I mean, we think we've got a map somewhere, haven't we?
We have.
It will take you not quite as far as Guildford, but certainly.
Maybe Sir.
Yeah. But anyway, let's assume. I mean, what, as I understand it, the complaint here is that because boundary fares haven't been widely publicised, people are buying a ticket from Richmond to Southampton Airport, not recognising, if I put it that way, that they've got a travel card for which they've already paid that will take them, for these purposes, on the travel card as far as the end of the zone. So what's being said is you should only have had to pay, having paid for your travel card, the fare from, let's call it Guildford, from Guildford to Southampton.
That's the basic.
That's the point.
That's
Now,
the basic
point. It's no answer to that point, that what you bought from Richmond to Southampton is an advance fare. Because you're still paying whatever, even if it's at a discount, you're still paying from Richmond to Guildford when you shouldn't be.
That's essentially it. So what we say is there's no reason why they shouldn't offer a boundary fare for an advance fare.
So the boundary fare from Guildford to Southampton, in this example, you say should have been an advance boundary fare. And the fact this is an advance fare as opposed to a full fare is wholly irrelevant as a matter of logic to the point that you're making.
Oh, yes. And we say that's a more than merely arguable case, and the tribunal agreed with us.
Yeah.
Whether that is something where they win at trial or not, we'll see. But what the tribunal said, so I was reading the Kids for a Quid, that the next bit was, in practice, as Ms Abram pointed out in a different context, these promotional fares account for a minimal part of the claims. Anyway, Kids for a Quid are not in issue. The only one which appears to be of any significance is the advance fare. And then here is the finding. Whether it could be an abuse for the respondents not to offer an advance boundary fare does not seem to us straightforward, especially if advance fares are available for most types of journey. And that is the finding. That's the finding that my learned friend has to overturn here, that the tribunal found it not straightforward and allowed it to go forward to trial. I mean, in any ordinary strikeout case, it would be remarkable that we should find ourselves in the Court of Appeal on this sort of point. It's only because we're here for a number of other reasons, I submit, that the court is entertaining this point. But the tribunal says they can see some force in Mr Harris's submissions, but we think if there's to be evidence and investigation, it's preferable for this matter to be addressed in the context of the abuse as a whole. And citing Lord Justice Floyd in Easy Air, in TFL, Lord Justice Floyd having cited Easy Air, saying the court should consider very carefully before accepting an invitation to deal with single issues in cases where there will need to be a full trial on liability and so on. Moreover, Mr Holt explained, if the tribunal was at a later stage to decide that journeys on promotional fares should be excluded from the claims, it should not be difficult to adjust the aggregate damages accordingly. And I've explained my point about advance fares in that way. So that's what the strikeout is, and I respectfully say there's nothing in that strikeout at all, and I've dealt with it sort of en passant, but I therefore needn't come back to it at the end. There is then a point made that group discount fares may be cheaper. In principle, the answer of, and more broadly, promotional fares generally, and my learned friend says no, they should be excluded. The answer in principle on promotional fares is the same as on advance fares, which is they should be made available in principle. But we have always accepted that for certain fares, it may not be proportionate to expect a boundary fare to be available. So for instance, Kid for a Quid and Group Save, where it may not be possible if only some members have travel cards, we have accepted that as being excludable at trial, and Mr. Holt has said they will be easy to exclude because they are just kinds of fares that you can take out. And just for your note, in our reply at paragraph 26C, Supplementary Bundle 1, tab 8, page 214, we make the point that we've never said we want to claim for Kids for a Quid and the like. So Mr Harris and Mr Jowl are pushing at an open door there. These are the sorts of tickets that can be cleanly excluded. And anyway, these promotional fares, these, shall we say, random promotional fares, are a tiny proportion of the claim, as we've just seen in paragraph 66 of the judgment. That's what Ms Abram for South West said below. And she's obviously right, because she was no. So we're talking about some minute fraction here. And that brings me to the more complex point on point-to-point fares. There are 2 points made against me on point-to-point fares. One is that this is an allegation of a failure to mitigate, and I'll come back to that when I deal in more detail with Mr Jowell's points. The first one, which was made by Mr Harris, is that the methodology isn't capable of excluding point-to-point fares. So the situation, it will be recalled, is that if the passenger actually bought a point-to-point fare, this is now outside the class definition. And when I talk about point-to-point fares in this context, we're not talking about any point-to-point fare. We're talking specifically about a fare from the last station in Zone 6, say, to the destination. So Mr. Giles said, well, you can do that. That may have the same effect. On the point-to-point removal methodology, my learned friend Mr. Harris again asserted there was no methodology before the tribunal as to how those fares were to be excluded from the aggregate damages calculation. That's a quote. End of quote. And he argued that Mr. Holt merely asserted that this could be done. In fact, the CAT had explored this issue with Mr. Holt in some detail in the witness box. And Professor Mason questioned Mr. Holt with an intervention from Mr. Holmes on day 3 to understand how the adjustment could be made. That is in Supplementary Bundle 2 of tab 19. An extract from the expert's examination. It starts at page 609 of Supplementary Bundle 2. And you may find that somebody has inserted a page, might now be double-sided at the beginning, at 609A
Yes.
and B. That's because the cross-examination actually started 2 pages before the pages in the bundle originally. The cross-examination so starts at 609A, Professor Mason at 11. If I could take us on to an issue which spans step 2 and 3, we're particularly interested. I know you will no doubt have been following earlier discussions and submissions about the treatment of travellers who hold point-to-point tickets. And yes, and then at 24, Mr. Holt says, he's the A, point-to-point being in this context a passenger who actually did buy a point-to-point fare towards the outer boundary of the last station before the boundary of their travel card holding, as opposed to one from the station at which they actually got on. That's my understanding of the point-to-point definition. And Professor Mason agrees. And Professor Mason at 8, that does include journeys which could be taken as point-to-point fares by a traveller who has travelled part of their total journey with a travel card, and then the final leg with a point-to-point fare. I think the answer is yes, and then there's some discussion on how the data works, because the stations aren't always exactly on the boundary. In fact, they rarely are. And Mr. Holt explains at 50 and 16, such a ticket would show up as an entry at Clapham Junction in terms of the fare. My data does include the point-to-point traffic that would be associated with that particular case. It may be, depending on the travel card assumption holding mix of passengers at that particular station, obviously then there is some proportion of those who are deemed to have a travel card under methodology. And there's a discussion of that. Over the page 610, Mr. Harris has a question. Mr. Harris, no, I don't have a question. I'm sorry. And then there's some discussion about the savings in relation to such point-to-point fares and what effect that would have. I would like to take it up again at 611, if I may. 611.3. You could, Professor Mason says to Mr. Holt, you could construct a means by which point-to-point journeys made by travel card holders as part of that overall compound. I think you were beginning to describe how you might go about excluding those particular point-to-point journeys. That's correct. At the moment, we only have estimated rail trips, so I would still need the disclosure information to revise and update that. But even on the current assumed rail traffic, you can identify for the cases where the starting point is, for example, Clapham, where it's assumed they have a travel card, then you could remove that proportion of journeys from the in-scope journeys. Professor Mason cites the example, the popular example, Waterloo to Guildford via Clapham Junction, and again explains how it works. There will be trips from Clapham Junction to Guildford which are people only travelling from Clapham Junction to Guildford. There will be trips from Clapham Junction to Guildford which are travel card holders who have come from Waterloo. Yes. And then let's just deal with those two categories for now. Between those two categories, that's the entirety of the journeys between Clapham Junction to Guildford. How would we disaggregate the total number to isolate one or the other? I don't think I have the data to do that at this time. Right. So that would be the evidence that would be derived from the further survey. Okay. Because that's the evidence that would provide a more specific breakdown of the travel card holding status of people at any given station. Okay, thank you. And then this next answer is important. Mr. Holt says, I don't know that anybody is doing that particular route, i.e. getting on at Waterloo, but getting a point-to-point in Clapham. Obviously, to the extent that people are doing that, it will increase the number of trips in the Clapham Junction origin part of the model. So if that is happening, then it will feature the evidence in the model, and indeed in the evidence to be disclosed, as an increase relative to the people not using this strategy. The level of Clapham Junction originating trips, as opposed to, for example, London Waterloo. And Mr. Holmes interjects. Again, he repeats the situation about the data being available. That's right. All the fares data would basically say Clapham Junction to Guildford. Mr. Holmes understood. Thank you. Yes, that's right. Now, this was obviously a discussion between economists. Professor Mason is a professor of economics. Mr. Holt is an expert economist. Unpacking what Mr. Holt says there between 9 and 16 at 612, the removal of point-to-point fares is not a matter of enormous complexity, certainly not in a jurisdiction where the tribunal is used to econometric modelling, which this certainly isn't. The way it works is that after disclosure, the number of point-to-point tickets will be apparent from actual ticket sales, which the defendants possess. And as Mr. Holt here also says in his evidence, the difference, the relative difference to be stripped out, will be any disproportionate amount of tickets originating at Clapham Junction at any end of zone station when compared to the actual footfall and relative size of that station. And if required, a more refined estimate will be arrived at through the survey. So that's what he's saying. It will increase the number of trips in the Clapham Junction origin part of the model. So he will be able to see, by looking at Clapham Junction, he will be able to estimate whether there is a disproportionate number of tickets from Clapham Junction to the end station compared to the number that one would expect. And that was explored by the tribunal with Mr. Holt. It's recorded in summary form at the judgment at paragraph 161. And we also refer to it in our reply. I'll come back to that when I talk about mitigation. So that's how it works. And that was accepted by the tribunal, having elicited that information in the tribunal's own cross-examination.
Just to understand it at a very elementary level, you take Clapham Junction,
Yes.
you look at journeys from Clapham Junction to other destinations outwards. You compare that against what you would have expected otherwise from Clapham Junction, and from that you deduce an increment. You therefore have to have a baseline, but presumably there is some method of working out what but for point-to-point you would or might have. That may be estimation or whatever.
Yes.
But that's the essential technique which was being debated.
That's right. That's what you get from that penultimate page of the cross-examination.
There may be all sorts of issues about calculating the baseline, but I suppose that's just part of the regression analysis.
That is part of the analysis. I mean, he will do that by looking at the data of ticket sales and combining it with a survey of the number of people who might be expected to be travelling from there as opposed to from Waterloo. So in other words, that's the stripping out of point-to-point fares methodology. It is not rocket science. It is not something that has to be done at the certification stage, nor can it be. But that is the plausible methodology that Mr.
You
Holt.
haven't got the evidence yet because disclosure hasn't been given.
That is right.
But what he's saying here is, well, when I've got the disclosure, then my methodology will enable me to answer the point.
Will do, yes. So his methodology, which includes the refinement of the survey, will enable him to answer the point. And of course, it will be estimated. That's the methodology. So I'll touch again on point to point when I talk about mitigation at the end, but that's in reasonably brief order. That's how that works. We then have, as quickly as I can, the other specific points I've really already addressed. Forgotten travel cards at home, I say that's presumably de minimis, or it can be adjusted via an aggregate discount. At least in the skeleton argument, South East include travel card not valid for the requisite period. There were echoes of that in Mr. Harris's submissions. But that falls outside the class definition, which requires a valid travel card to be held. So we say that's not an issue at all. Savings too small to bother, passenger in a hurry, reimbursed in any event, non-price optimizing travellers. And these are the scenarios that I've clustered together as the essentially irrational scenarios. And as I've already discussed with the bench, it also appears to assume the wrong counterfactual, where the boundary fares are still that much more onerous to purchase, extra effort, and therefore need a meaningful incentive. That ought not to be the case in the counterfactual. Mr. Jowl added the argument on his feet that some people may just not bother for a small saving, say the price of a Costa coffee. I have to submit here that my client, Mr. Gutmann, is very forcefully of the view that that is not the correct approach a court should take to a consumer class. We in this courtroom may not think twice about a £5 saving. That will not be a uniform view taken across a class of consumers.
That's why, when that point was made, that's why I thought of Deutsche Post, which is whether or not that option ever arises. If mechanistically on the TVM, it simply comes up with a price, not an option or a choice.
And that's why I say it misunderstands.
Price or price plus cost of coffee.
Exactly. That's why I say it misunderstands our counterfactual. That's the basic.
That's the point there. I mean, if you go back to the example my lord and I discussed with you earlier, so you've set up the system so the ticket machine or the internet, doesn't matter which, when you feed in your journey, asks you the question, do you have a travel card? And then you say yes, and it asks which zone, and then it gives you a price. Now the hypothesis, that's the counterfactual. But here the hypothesis is that when it asks you the question, do you have a travel card, you can't be bothered to answer. However much of a hurry you're in, it seems to me it may be, there are some people out there who don't. But the vast majority of people are going to answer that question yes, if they've got a travel card.
My lord, exactly.
A40 if they know that the effect of doing so is they get a cheaper fare.
Exactly. So that is that, and there is an overlap in these points between the points made by Mr. Harris and Mr. Jowl. In my notes, I've finished now with points made by Mr. Harris. I'm starting on points made by Mr. Jowl, but I've already pre-advertised really most of them. So, for instance, the passenger goes to a travel ticket vending machine which has a boundary fare but fails to purchase one. I mean, that's the point just addressed by my lord, and that's the exact argument. Another point made by Mr. Jowl was a passenger purchases a fare from a ticket desk but fails proactively to mention travel card. Well, that, with respect, it suffers from the same difficulty, that this is again a scenario that does not appear, with respect, fully to appreciate the nature of our counterfactual. Where there's a general availability and awareness of boundary fares, the passenger, in the first place, should not have proactively to mention travel cards. It should be mentioned by the ticket vendor. And this is also a situation that's, I suppose, comparable to someone who has a rail card but fails to use it. The holder of a rail card will know what the rail card does, will know that she possesses one, and it's already been mentioned in discussion with the bench that ticket counter staff do ask for rail cards without apparent difficulty, and it appears unlikely that a situation where a holder of a rail card forgets to use it would be particularly common. So, again, these sorts of imperfect counterfactuals, if they can lead evidence at trial that says, well, actually 1% of people forget their rail cards, that might be a useful comparator for an aggregate reduction of 1%. There was a similar scenario, at least in the skeleton argument, of a passenger being aware of boundary fares despite the unavailability of information. The reason I say that that's a similar scenario is that if it's meant to illustrate a case where people don't buy the boundary fares in the counterfactual, it is an irrational scenario. It has to assume not only that the passenger is aware of the boundary of a boundary fare, but also that she then didn't buy one for no apparent reason that's given, because otherwise she wouldn't be a class member. So I say there's nothing in that. I've dealt with passengers forgetting travel cards. There is an extra scenario that was added orally, but that was not new. It was also below, where travel is expensed. Mr. Jowl asserts, based on his client having hazarded this same argument in a witness statement, Mr. Jowl asserts that employees would not feel obliged to buy a boundary fare if they're reimbursed. I leave the ethics of that for another day, but this, in my respectful submission, is not a basis on which the tribunal ought not to have certified the class. They can make all these points at trial. They can make them in evidence. If they can get through with it, it's another prime example of a potential reduction, if it flies.
But if it's done, I mean, in the counterfactual we've just been discussing, where it's, as it were, done automatically by the ticket machine or by the internet, it doesn't matter whether it's a business fare or for which somebody else is ultimately paying or not, because
In this case,
on this hypothesis, it automatically gives you the cheaper fare.
well, to be fair, I think in this case, Mr. Jowl asserted that the passenger would proactively do something not to use his boundary fare, his travel card.
That would mean that if the pop-up on the screen said, have you got a travel card, you'd be postulating a traveller who did have a travel card but who pressed the button and said no
Yes.
to get those.
Yes. And that brings me to Mr. Jowl's last scenario, which is very similar to Mr. Harris's strikeout. No, not strikeout point, to Mr. Harris's point about point-to-point fares. And that is an allegation of a failure to mitigate. So Mr. Jowl's last scenario was, you could have had a point-to-point fare and therefore you could have mitigated. I should say that there is a slight difference between the parties. When we're talking about awareness of point-to-point fares, it's been suggested that everyone agrees that people are aware of point-to-point fares. When we talk about a general awareness of point-to-point fares, we mean tickets from one place to another. In particular, we absolutely, of course, do not accept that people were generally aware of this mitigation strategy, and is simply another way of describing the same abuse, in the same way that people weren't aware of the existence of boundary fares, or in a near analogy, we say, people will not have considered that point-to-point fares from the last station are a mitigation strategy. That would be for discussion at trial. But this is the test. The test here for mitigation is, would it be reasonable for the traveller to have done so? Again, par excellence, a case for trial. We have addressed this in our reply, and it may suffice to turn it up. That is at Supplementary Bundle 1, tab 8, page 233. The suggestion that the proposed class members failed to mitigate in failing to purchase a relevant point-to-point fare implicitly contends, by alleged contributory negligence, that purchasing such a point-to-point fare should have reasonably been in class members' contemplation. The CR anticipates that if such P2P fares were widely, that is from origin stations other than the one where the customer actually started, were widely available and customers were sufficiently aware of their existence and the ability to combine these fares with their travel cards, such that it could be considered that the proposed class members should have reasonably availed themselves, then ticket sales data will show a large number of point-to-point fare purchases from the various near-boundary stations out of proportion to the footfall of these stations. If, however, the data does not show a high volume of point-to-point fares purchased by class members from boundary stations, the obvious inference is that such fares were not widely available, and or their availability and use not widely known, which will undermine the arguments. Thus, this is a matter which disclosure will elucidate in due course, although it is presumably within the proposed defendant's knowledge, and so forth. In reality, the proposed defendant's suggestion that class members failed to mitigate a loss they were not even aware of, by a means, if anything, only marginally less obscure than boundary fares themselves, appears fanciful.
There's an overlap with the concept of abuse, because abuse, I think it's at least it's common ground that I know there's a dispute about availability, but accessibility in terms of sufficient transparency for consumers to make a choice and to obtain the best fare. If the tribunal were to find that there was a general cloud over the facts, it may find it difficult to then say there was a duty to mitigate, because it would already have assumed that there was a lack of transparency.
My lord, yes, and at least for the first year of the abuse, of the relevant period, these tickets weren't actually available at the origin station. So there's that. And then afterwards, it is not known whether they were generally available, for instance, from ticket machines. That would be a matter for evidence. That may vary. Southwest may again be different here than Southeast. So there are all these issues. And yes, it's not just mitigating, like in a tort case where you say you could have done something. They have a special responsibility as the dominant undertaking. And simply to say, again, I agree, it is a close analogy to the business of pressing the right buttons. Simply to say again, well, you know, you consumers, you could and should have done something about it. I submit is not an attractive argument. And this is squarely an issue for the evidence. And it's clearly a common issue. There's no evidence to suggest, even conceptually, why for some class members this should have been different than for other class members. And as such, the tribunal was, in respect, entirely correct to find the way it did. So then my learned friend reached his conclusion, and he complained that Mr. Holt's estimate of loss would need to be discounted in these various ways if he were right. Yes, but I ask rhetorically, what's wrong with that? That is what we say. Where we differ is that we say that Mr. Holt is entitled to make a reasonable assumption to reach his figure and then work from that. And we know that my learned friend agrees in principle, my learned friend Mr. Jowl agrees in principle with the use of assumptions in competition cases, and he said as much when questioned by the bench. It's of course a very common approach in expert evidence in competition matters. Mr. Jowl disagrees that an assumption can be used in this case, but it is on analysis, I respectfully submit, not a distinction that is sustainable on any reasonable basis. His only argument on the point is one. I mean, it is his argument, and I will address it. It is to assert that this somehow reverses the burden of proof. At trial, however, the burden of proof will fluctuate between the parties, as it always does. We will assert people won't pay twice for the same service. And we'll talk about Deutsche Post, and we'll talk about how unfair the system is, and we will have Mr. Holt's evidence. They will assert, I suppose, that people would, in their various scenarios, for different reasons, have paid twice for the same service. And if they can, they will bring not just these more or less exotic examples, but presumably they're going to try and say that somehow across the board. They might even allege that, well, everyone knew about this. As Mr. Giles said, everyone knew about point-to-point fares. What's the problem? And if he's right, he's going to win. But what they're saying is we can't even assert our central case. Our central case, which is that this is double charging, and it wouldn't happen if there were price transparency. That's it. And they failed in their arguments below when they said, well, you can't, this is a consumer type case masquerading as a competition law claim. It's not an abuse to say this is double charging and there should be price transparency. That was Ms. Abrams' case below. That failed, and there's no appeal against it. The reversal of burden of proof point is really the same sort of point in a different guise. And my learned friend came very close to revealing that when he repeated the assertion that this is really about consumer law, not about competition law. Plainly, the CAT disagreed. Plainly, the CAT found that this is simply not a matter which can be said at certification to be either not more than merely arguable or implausible on its methodology. And it is a matter on which this court ought not, indeed I say cannot, overturn the specialist tribunal, because you would simply be second-guessing what they thought about that. So the existence of an abuse is now a given. The CAT has found that there is the potential for a breach of competition law, no appeal against that. What remains is evidence. And by saying that the evidence is going to be disputed in the way that it always is in competition cases, or in many competition cases, that you don't turn it into a legal point about the reversal of the burden of proof. So that's all I wanted to say about the scenarios. There are two more areas that I want to deal with. One is the point about third-party sellers, and the other is cost benefits. Before I do that, quite briefly, I have a couple of random responses to some things said by Mr. Zhao. And I'll just take those one after the other. So my learned friend, Mr. Zhao, went to Mr. Cameron's witness statement in Supplemental Bundle 1, page 257. And he went to paragraph 24. This is a small point, but I feel I need to make it anyway. He looked at paragraph 24 and he said that he read out that any TOC can sell fares for use on another TOC services. Sales of rail fares for use on South Western are broken down by sale channel and retail in the chart, and then confidential percentage, I'll call that X% of first MTR's earnings sold by first MTR are from TVMs or station ticket offices. With the implication being that boundary fares were at least in theory available in the overwhelming majority of cases. Well, I don't with that implication. But what I want to address is that, to be precise, it's not actually X%. It's X% of whatever percentage it is of the tickets for travel on South Western that South Western sold itself. And you can see that from paragraph 28 of Mr Cameron's witness statement. I don't think this is in dispute. 28 starts at 258, over the page at 259, for those who have numbers. I note that for the 2018-19 rail year, sales of rail fares for use on South Western Railway's network was split approximately a confidential percentage for first MTR. I'll call that Y%, another percentage for Cox and another for other retailers. So what we're really saying is the percentage sold at TVMs and ticket counters is X% of Y%. We can all work that out, if it even matters. But I pointed out for the sake of the avoidance of doubt, just because the percentage, X% of para 24 looks so stark. Another point, we'll put that away for now. I will have to go back briefly to Mr Cameron's witness statement, but for now I want to move on. My learned friend also said at one stage, if I heard him correctly, that the abuse affected something like 1 in 20 customers on our figures. I didn't understand, I'm afraid, what he was referring to there, and again, it might not matter at all. As I've said, the number that we give for travel card holdings is 12 to 18%. Maybe that's what my learned friend was thinking of. I make that 1 in 5 to 1 in 8, but again, it may not matter. I just I pointed out in case he wants to come back on it. My learned friend then talked about savings on travel cards, including the potential for zero savings. My Lord Chancellor may recall this discussion. My learned friend pointed the court to footnote 220 in Mr Holt's report, and he said no need to turn it up for his proposition that there are plenty of cases where there are zero savings. I must ask the court please to turn it up. It's in Supplementary Bundle 2 at page 421. It's in footnote 220, goes with the paragraph that is set out above, paragraph 6.2.48. And under A, negative savings for certain pairs and fare types. The ATOC data, that's the defendant's data, suggests that the saving for an equivalent boundary fare is negative. This could be due to, for example, the boundary fare assuming a different route or combination of routes than a more direct fare would suggest. There's a rather complicated explanation. For example, from Hounslow to Bagshot, there's one full journey fare, one choice of route, any permitted. For a boundary zone 5 fare, there are 2 routes via Ascot, which has a 0 fare difference, and any route permitted, which is more expensive. As I average the 2 boundary fare routes, the boundary saving is negative. And importantly, over the page at 422, in terms of materiality, there are 2,805 negative boundary zone savings for all pairs and fare types in the database. For Southeast, that's 0.9% of the total, and 434 for Southwest, 0.1% of the total. Therefore, while I consider that an adjustment should be made in relation to these anomalous estimates of boundary savings, due to the low proportion of these occurrences, I do not expect this assumption to have a significant impact on the overall result. So the context in which a saving might be 0, as footnote 220 explains, the context of that is that we are dealing with an extremely rare set of circumstances. To explain that further, my learned friend also pointed the court to the table on table 6.16 on page 424, which illustrates this footnote example. I think that's the table he went to. He may have gone actually, I think, to 426 and table 6.18.
Yeah. 6255. Yeah.
Yes, that's right. And my Lord the Chancellor picked up on the red shaded negative savings. Now there are two things going on here. The zero savings that the footnote refers to arise in this way, as explained in that paragraph. If you travel from a station close to the boundary of a zone, where even tickets from a station that is not the last station before the boundary might be priced the same as a boundary fare because it's so close to the zone, as the footnote explains, stations are often grouped together for fare purposes. And that explains the 0% savings in the table. And then the negative figures in the table, the red shaded cells, the explanation there is the one that we saw in 6.248a at page 421. They are the rare circumstances in which a boundary fare produced negative savings. And this table, these tables, and this one in particular, were clearly chosen so as to include an example of these 0.1%. This is the Clapham Junction to Wraysbury example. That's the 0.1% of all journeys on South Western where by a quirk there is a negative saving. That arises because these zones are big and there may be more than one route, typically no more than two, from different points on the edge of a zone to a certain end station outside the zone. The routes have different lengths. In these cases, what happens is that the system, the boundary fare system, means that the fare would be valid on either route. If you're travelling on the shorter of the routes, it may, by a quirk, be cheaper to buy a full journey fare than a boundary fare, which is also priced for the longer route. But as Mr. Holt says, this is an exceedingly rare scenario.
Apart from the pleasure of giving Mr. Jowl a swat, what point are you replying to in relation to him? What's the legal significance of this?
I don't think there's any legal significance. I think it was a sort of jury point that, well, sometimes a boundary fare might actually be more expensive.
Forgive me for intervening, but I went to this table for a quite different purpose, which was to simply show that the savings could be low. I went in to show that it could be 40 pence or 70 pence, not to show the negative savings. Nor does Mr. Holt state anywhere in this report that I could see that this is an example designed to show negative savings.
Well, there it
On
is.
the ground that it would need to be taken into account in some way, shape or form. Mr. Holt accepts that,
Yes, a 0.1% reduction perhaps.
whatever it is.
But yes, well, I accept Mr. Jowell's point that sometimes the savings are 70p, sometimes they're £9.22, as in the first line of table 6.18. So there we are. In the time I have left, my lords, I have two more points. The first one is about third parties, and the other one is about cost benefits. They're both points made by, they're points made respectively by Mr. Harris and Mr. Jowl. So third party sellers is my learned friend Mr. Harris's strikeout point. South Western don't appeal this. Our case on the third party, our primary case on the third party sellers, was that it is a form of agency. And our secondary point was, in any event, the TOC's behaviour will impact the third party's behaviour on the sale of boundary fares. And it is dealt with at section F of our skeleton argument, starting at paragraph 75 of our skeleton argument, in this case. And as your lordships, my lady, will have seen, our primary case is third-party retailers, that's at 76, act as agents for train operating companies, which therefore are liable for their conduct. The tribunal expressed some doubts as to the extent of such an agency relationship, but with respect correctly considered it wasn't a question it had to decide at certification. Accordingly, refused to strike out the claims. My learned friends did then also complain about the tribunal's umbrella analogy. Now that's an alternative point on any view. It's a point that we've gratefully adopted since. We did always plead a version of this. We see that, for instance, in our reply. That's in Supplementary Bundle 1, tab 8. At pages 218 to 220. Our pleaded case on third-party retailers in reply to their complaint. And at 38 on page 219, we said this. We said, second, and in any event, it is easily apparent that the proposed defendants could themselves have remedied the abuse, irrespective of the fact that some fares were being sold through third-party retailers. The practical effect of the proposed defendants themselves making boundary fares sufficiently available and publicising their availability would have been to give third-party retailers every incentive to make them available as well. Third-party retailers already make available a large range of discounted fares, including young persons' rail cards and group savers, would likely be unable to attract eligible passengers if they didn't offer such discounts. And my lords, again, a similar point to what I said in relation to advance fares. It can't possibly be said that there isn't a more than merely arguable case that one or both of these points will fly. Now, my learned friend Mr Jowl yesterday relied on the paragraph 28 in Mr Cameron's statement that he disavowed today for this point. It seems, therefore, that at the very least this is a matter that is very, very complicated on the facts. This is where I think there's been the offer of some further explanation or evidence, should the court want it. In my respectful submission, the court ought to decline that kind of offer. It's not necessary. If it's going to be very complicated and require further factual elucidation before this court, that wasn't even available until it was noticed today, and certainly not in the courts below, then it is plainly not a matter that is fit to be struck out at the certification stage. I would like very briefly to look at Mr Cameron's statement and also Mr Backway's statement, which my learned friend Mr Harris referred to and from which he has not resigned, and just tell your lordships what our case was on this point. So Mr Cameron's statement is at Supplementary Bundle 1, page 258. That's the paragraph my learned friend went to. I've already gone to it for a different bit of it today. Mr Cameron says, generally speaking, prices are the same irrespective of the retail. While signatures to the TSA, that's the agreement between the TOCs and their third parties, are required to sell particular fares, the same obligations, that's the agreement between the TOCs. While signatories to the TSA are required to sell particular fares, the same obligations do not extend to third parties. Third parties are licensed separately by RDG. That's the Railways Delivery Group. The Railways Delivery Group, I think I'm right in saying, is all of the TOCs collectively. So they are licensed separately by RDG under a third-party investor license, TPIL. Individual TOCs cannot require third parties to sell particular fares, including boundary fares, or dictate to them how fares should be sold. The word individual is doing a certain amount of work in this paragraph, although I fully accept Mr Jown's point the paragraph is no longer to be relied on. But what our case on this is that TOCs can't individually make the third parties sell boundary fares because it's the RDG, it's the TOCs collectively who would have to require the third parties to sell particular fares, subject to contractual negotiation. And that is the same point that may be made about Mr Backway's statement at 313, paragraph 76. Mr Backway uses similarly careful language in his statement. He says third-party retailers, 76, page 313. Third-party retailers are licensed by all TOCs acting together, along with RDG. LSER has no individual contractual relationship with third-party retailers and no means of dictating terms, and so on. Yes, but if there were a finding against these TOCs, then collectively we say, and we said that in our reply, for your notes, that was a paragraph 39 of our reply, page 219 of this bundle, we said it is simply inconceivable that other TOCs would have stood in the way if the court identified an insufficient availability of boundary fares as problematic, and the same if the defendants, properly in accordance with their duty under the Competition Act, had identified an insufficient availability of boundary fares as problematic and unlawful, and had wished to remedy the situation by amending the relevant schedule. There's no evidence that the defendants ever tried, and of course they strongly deny that they have to. So that's the point on third-party sellers. It is at the very least, as we heard this morning, factually highly complex, therefore not fit for a strikeout on any view. I'm sorry, that's a master level submission, but I make it because it's there. Last point, question of costs budget and the cost-benefit analysis. That is dealt with in the judgment at paragraph 178, core bundle page 200. I'm sorry I'm going slightly over, but my learned friends did have a few minutes at the beginning this morning.
Give us the highlights then, so they have their full hour.
Yeah, so I mean, so the conclusions that ones have made, they've had regard to all of these considerations. All of the considerations are all of the considerations in Rule 79.2 of the guide.
Cost-benefit analysis is just one of the factors
That's right.
that the CAT has to take into account in reaching its multifactorial assessment of whether or not it's appropriate to make an order.
My lord appears to have had my script leaked to his lordship. Yes.
Like the Supreme Court of the United States.
Yes. So indeed, and this court would have to be persuaded that they got it not only wrong on that one point, but so wrong that it somehow overbears all of the points.
So that's the point I was making.
And anyway, also this point, my lady, my lords, the costs are something classically within the CAT's ongoing supervisory function. Rule 85.2a of the rules, that's at Authorities Bundle 42, page 1576, that says that the CAT can continue to manage and supervise this, and if necessary, can rescind the collective procedure order even. Now, all these points about these very costs, the same level of costs that Mr Jowl mentioned, were made to the CAT at the PTA hearing.
Yeah.
The CAT didn't change its ruling, didn't revoke the CPO, neither should the Court of Appeal accept Mr Jowl's, however beguiling, invitation to do so now, and that's at our skeleton, paragraph 72 to 74, to which I have nothing to add. Unless I can assist the court further, to my submissions.
Thank you very much. Hang on, you've got something.
Oh, I have the information about what was and wasn't in the bundle. In the CAT, Preventex was in the bundle, Facebook was not in the bundle. We'll get the translation that exists of all the federal court judgments to the court.
Thank you very much, Mr. Moses. Yes, Mr.
My lord, my lady, you'll be pleased to hear we're well on track. We have an hour approximately divided between me and Mr Jowl. I'll take slightly more of that, but we'll be finished for the lunch adjournment. My respectful submission at a big picture is that this court should not feel shy from realising that there are certain fact patterns that shouldn't be certified as collective actions. This is just such a case. My learned friend said at one point in his submissions that it would destroy the regime if this one is not certified, because if this one is not certified, then none would be certified. But that's a false proposition. the problems in this case about the individualisation and the bespoke nature of the liability analysis did not afflict, for example, Merrick's or Le Paterel. They haven't afflicted McLaren or Qualcomm or Kent versus Apple. They haven't afflicted any of the other cases. That's my point about there being my submissions and Mr Zhao's submissions applying to a subcategory of a subcategory of a subcategory. Indeed, the problems of this case won't afflict any case, consumer protection or otherwise, properly dressed up as a competition case or otherwise, if they don't have a heterogeneity of individual circumstances going to the liability analysis. So it's, as I said in my opening, scaremongering. Indeed, in this case, has another problem. It's not only that it's in the subcategory of the subcategory of the subcategory, but it has, in this case, it's completely common ground that the data on one of the critical questions, what the Linear Tribunal described as, on 4 occasions, as challenging or the most challenging, the so-called overlap, it simply doesn't exist, and it never will exist. If you were to turn up, I'll give you the reference, I can just read it out, in the supplementary bundle number 1, tab 8, page 239. This is my learned friend's pleading, and it bears upon another point. He's pleaded as follows. Whilst on further consideration, Mr Holt no longer considers the travel card agreement a possible source of data to estimate the proportion of in-scope journeys made by passengers who hold a travel card. So it's completely common ground that there is no data, but since we were talking about travel cards and whether or not it's a possible source of data, it's pleaded unequivocally that it is not a source of data on that point. And that's always been the case. And that's another reason why this is a particular fact pattern where the court shouldn't feel at all shy, if I could put it like that, about saying that certification was wrongly granted. It necessarily requires, for a central part of the methodology, a certain type of data, but it just so happens on this fact pattern, it doesn't exist, and it never ever will exist. That takes me on then to a fundamental point. Those were, if you like, opening issues. My Lord Justice Green suggested a proposed interpretation of section 47C2. So this goes to the heart of my what was called first alternative submission. And perhaps we could just turn up section 47C2 again and have that in front of us whilst I respond to that suggestion. It's to be found in Authorities Bundle 5 at tab number 41. And I'll want to just flick through a few of the pages, beginning on page 1559 in a moment. If we could just perhaps have that available to us. Page 1559. But with respect, the suggestion that was put in argument by my Lord Justice Green to Mr Moser was not suggested at any point by Mr Moser. That's not been an interpretation. It wasn't suggested by Lord Sales or Lord Legat in the minority dissenting judgment in Merrick's. It's not been suggested in any of the cases by the former CAT president, Mr Justice Rock, in, for example, Pride or in Merrick's, or indeed in any of the other cases that he has certified, including this one, with his colleagues, of course. It wasn't suggested in McLaren. It wasn't suggested in Qualcomm. It's not been suggested anywhere else. And we say, with good reason, my lord, if I can put it like that, it doesn't appear in the words of the statute. Can I just begin?
Just put to me what my proposition was.
Well, I think your proposition was, my lord, as I understood it, that in order to ascertain whether there's nominal loss, that is an example of assessing the amount of damages.
And recoverable. Recoverability is important, isn't it? It's the principle of what is and what isn't recoverable.
My lord, I will deal with this.
Yeah.
But what I'd like to, if I may, just draw to the court's attention is if one begins on page 1564, 47C, it's interesting and indeed critical how this set of new statutory provisions that were inserted are described. So we'll look in a minute at 47A that came in by the Consumer Rights Act, then we'll look at 47B in a minute. But 47C is headed Collective Proceedings, Damages and Costs. That is what it's dealing with exclusively. It doesn't say liability. On the contrary, it's distinguishing between the previous two sections, 47A and 47B, that talk about the liability questions and what constitutes, I beg your pardon, the cause of action. So under 47B, this is two pages earlier, little 2. In this section, consumer claim means a claim to which section 47A applies. So under 47B, you can bring collective claims provided they're section 47A claims. And then if we go back, please, just for a moment to 47A, this one talks about what a relevant claim is, and the critical sentence is in subsection 2 of the legislation. This section applies to a claim of a kind specified in subsection 3, which a person who has suffered loss or damage may make in civil proceedings. So my respectful submission is that this structure is deliberate. There are the provisions about what claims can be brought, and they have to be ones for which a person, that is every person, has suffered loss or damage. And then it says that those are the types of claims under section 47B that can be brought collectively, but it has to be those types of claims. And then over the page again, we talk about a different subject, which is to say damages. Costs are irrelevant, but it talks also about costs. So in my respectful submission, it's a deliberate structure, and section 47C simply doesn't contemplate anything to do with liability. And that's why it doesn't use the word liability anywhere in it. On top of that, what it does do is it says in 47C2, the critical subsection, it talks about making an award of damages in collective proceedings. So those are the words in I think the 4th, 5th and 6th word, making an award. But in my submission, one cannot make an award of damages unless there's a finding of liability. And that is why, with respect, Lord Sales and Legat use that word antecedent in paragraph 97 of Merrick's. What they say, on their obiter view, what they say is, well, it also includes the antecedent questions. But that's my point. It comes first.
I understand that, I see the force of it, but nonetheless, if we read literally what the minority said, in Merrick's, what the majority said in relation to the pass-on defence in the Court of Appeal, what the Court of Appeal said, what they all said, arguably in law, they must have taken the view that 47C was to be construed as including liability and conduct, some way, somehow.
Well, I don't agree at all that the majority in Merrick's, which is for these purposes the key judgment, agrees with that, and I will address you on that in a minute. I simply don't accept that. And
we're aware of that.
But for reasons, indeed, it's flatly contrary. Let me skip to that.
Well, you made submissions about it in opening, so.
Yes. Well,
We've got that point.
Let me just summarise then. It would be a finding to the effect that 47C2 does encompass aggregate liability, in my submission, is flatly contrary to the majority judgment in Merrick's. And if this court were to come to that conclusion, it would have to say that that majority opinion is wrong for 3 reasons. Firstly, in paragraph 45, Lord Briggs for the majority said, and I quote, that all of these claims could all, at least in theory, be individually pursued by ordinary claim. And that would have to be wrong for 47C2 to allow aggregated liability, because an individual claim can't be individually pursued by simply ignoring whether or not there's at least nominal loss. Secondly, it would have to be wrong for the majority in paragraph 54, where he says, and I quote, that the claimants who have suffered, that the case was about, quote, claimants who have suffered more than nominal loss by reason of the defendant's breach. So that would have to be wrong as well. And then he'd also have to be wrong on behalf of the majority in paragraph 46, where he said, and I quote, the issues ... in the present case all relate to quantification, unquote. And then, as you know, that was followed by the 10 references at least to quantification and none to alteration of liability. So in my respectful submission, that would have to be wrong. And this court would have to say that it's wrong. And then that leaves me at the last point on this, which is, of course, Mr Moser recognises the difficulty with the wording in section 47C2. And this, I hope, deals with my Lord Justice Green's suggestion to him in argument. What it actually says is, I've dealt with making an award of damages, but then it says without making an assessment of the amount of damages recoverable. And it's plainly there in my respectful submission going to the assessment of the quantification, which is why that's the word that Lord Briggs so repeatedly uses.
So in your analysis, an assessment, there's a scale of damages from 0 to X. According to this, you don't have to undertake that, but you say they do if the argument is that the figure is 0 or nominal,
No, because that's not an assessment of the amount of damages.
recoverable in principle. How much would they recover? Because the answer might be 0 or 72.
But that's the question of liability, my lord.
Well, and understood, this is the distinction, the scale is, you're saying the first part of the scale is excluded from this assessment, and they have to carry that out to decide whether there's any loss at all, because that governs liability and causation. Once you've got to that stage and you've carried out that assessment, you then don't have to carry out any assessment for the further sum of money which might be recoverable, i.e. from 72 pence de minimis up to £100.
What I don't accept is the word an assessment of the amount of damages coming under the heading collective proceeding damages is talking about the antecedent question of liability, which is whether or not there is somebody who has a claim within the meaning of 47A who has suffered loss or damage.
In your view, that has to be analysed at the certification
Yes,
stage.
but it's not an assessment of the amount of damages.
But then they have got to do an assessment of the amount of damages to arrive at the figure it's nominal.
No, because, I understand the point that you're putting to me, but I don't accept that in any sensible reading of the word, an assessment of the amount of damages contemplates what your lordship's putting to me.
So nominal doesn't fall within that.
No, for the reason that I've just given, that that goes to the question of liability, which is why Lord Sales and Legat call that an antecedent question.
So your analysis, the word damages means anything other than 0 or nominal.
No, my submission very clearly is that 47C2 is talking simply about the assessment of the amount of damages, not the question of liability.
So in your view, you've got to get over that first hump.
You absolutely do.
And,
Yes.
and therefore you exclude from the hump 0 quantum or nominal quantum.
Well, I don't put it like that, my lord. I mean, my submission, as you know, and then I'm going to move on because there are obviously other points, is that that this regime is the same as the one in Canada, where you have to establish the liability first in order for you then to be allowed to go ahead and try to aggregate the quantum of any amount of liability. But in order to establish the liability, you have to be able, at a certification stage, you have to be able to have a plausible, credible methodology for saying that you've got something at least nominal loss for each person. And
I absolutely understand the point. Just help me with this, because I don't want to tie you down with it. How does this work in practice in this case? If we're with you and we remit it to the tribunal to find out whether there is any loss or anything more than de minimis loss, does the tribunal then have to carry out an assessment of 2 million claims to see whose loss is more than 0 or de minimis?
no, it doesn't have to carry out an assessment within the meaning of 47C2. It does have to ask itself the question, are these claims within the claims as described in 47A, each of them? And are they therefore, each of them, claims for which the person has suffered some loss and damage?
How does it do that in practice?
Well, that is a job for my learned friend's side. That is incumbent upon him to come forward with a methodology that enables him to say, okay, this is my credible and plausible methodology that allows me, that shows to you, only at the credible plausible stage for certification purposes, that each of the persons has a case of at least nominal loss. And what I said before, of course, is that in most cases this is not a problem. In all the other cases that have been certified, that's not a problem. In MasterCard and Merrick's, it wasn't a problem because the credible case for interlocutory purposes of certification is, did you buy the overcharged good or didn't you? In BT Le Patarellit, were you a BT customer or weren't you? In Qualcomm, it's, did you buy one of the phones in which there was an allegedly overcharged chipset because of the patent allegations, etc., etc. And so those cases, they don't have this problem. It goes back to my very first submission in reply that there are some fact sets that do have the problem. This is one of them.
And again, you're not advising Mr. Moser on this, but how does a claimant in abstract who has a class, let us say, of Merrick size, establish that each of the 46 million individuals has a claim which is more than de minimis? How do they do that?
Because in that case, that's a different case. But in that case, the theory of the case, which was accepted by MasterCard, was that there were so many MasterCard accepting retailers stroke merchants in the economy over the over the 16-year period that there was no point in arguing that an adult wouldn't have made a single purchase in at least one of those retailers at some point during the period, which was sufficient for the common issue at the certification stage.
Wouldn't it be the case that in MasterCard, that if there were retailers who weren't actually passing through the MIF, then the customers didn't suffer a loss?
Yes, but my lord, as I hoped to
So
have
there were
taken you
claimants in the class who wouldn't have suffered a loss.
but as I hoped to have taken you to in opening, my lord, perhaps I didn't make the point sufficiently clear, was that for certification in an indirect purchaser action that involves an overpriced good or service, process tells you exactly what you have to do at certification, and all you have to do, and one can well understand why, but all you have to do is say, has a single penny of loss made it through to that level of the chain? If you can show that, off you go. And that's what it said in process. That's what the case was about. And that, of course, is why in paragraph 46, just skipping ahead of myself a little bit, that's why the Court of Appeal expressly relies on process. It's notable in my respectful submission that my learned friend, and for that matter, Professor Mulheron, for what that's worth, they both have to say, oh, no, that was a mistake. That was a mistake in paragraph 46 of the Court of Appeal in Merricks. And if you agree with my learned friend's submissions, then with respect, you'll have to be telling your brethren in the Court of Appeal that they did make that mistake in paragraph 46. They relied upon it, they didn't understand it, and they misinterpreted it and misrelied upon it. But on my submissions about Merricks, that wasn't a mistake at all.
Using your words against you, Mr Harris, we won't be shy of doing that if we think that's the appropriate
My lord,
course.
I understand. But I put it like this in a rather different way, which is there are two rival interpretations of that trilogy of paragraphs. And on my interpretation, the Court of Appeal understood exactly what it was doing and did rely upon process for exactly the right reason. My learned friend's interpretation and that of Professor Mulheron, they didn't know what they were doing, they'd misunderstood that case and they misrelied upon it. That I say is quite a challenge. And then that leaves me only on section 47C2. So my learned friend obviously has to go, well, I say obviously, and indeed he must have thought obviously, because he goes straight to the question of necessary implication. That's how he says he gets past ex parte. Pearson, ex parte, Sims, and ingenious media. He said necessary implication, but I asked rhetorically, how can that be right? The words of the section don't mention liability, so I fail to see, and he didn't address you on how the words of subsection 2, on the words, necessarily imply that it includes liability. He didn't address you on that, and I don't see it. It's never been addressed in any judgment. It's never been submitted. Mr Moser doesn't submit it. So that rules out one option. Necessary implication by the words is not even advanced. And he didn't deal with it with the way that I put it in opening, which is I said it can't be necessary implication as a matter of the structure and logic of the regime, because the, quote, best model, unquote, for our country is Canada, and Canada emphatically doesn't do this. And he didn't deal with that. So he just ignored both of those points. He says, my case is necessary implication, and then he doesn't explain how they're either necessarily implied by the words or by the functioning of the regime. And then I end here because I deliberately stressed when I took the court to extract from ex parte Sims in, I believe, ingenious media, or certainly one of them, where it said that one doesn't do this as a matter of the law of England. Read in massive extension of the substantive law of the land to the disadvantage of the citizens of the land. Because it could easily escape scrutiny in the democratic process. And again, Mr Moser simply doesn't engage with the point. There is no Hansard before us. There are no consultative papers, of which there are many in the authorities' bundles, that at a single place says, oh yeah, this is also doing two things. They just don't say that. And one can only imagine the debate that would have been engendered in the democratic process if it had suddenly been said that not only can you aggregate quantum, but you can actually aggregate liability to the disadvantage. So there we go. That's what I have to say about that. And that's critical, of course, on the what I call the first alternative. Skipping topics, I'm going to develop only a few of them in reply. Distribution. Mr Moser, curiously, in a manner that I with great respect, couldn't understand, relies upon distribution as somehow being in his favour, but there's a fundamental problem with it. Distribution is completely irrelevant to the issues in these appeals. By the time of distribution, by definition, all issues of liability and damage have already been determined. But these appeals are about earlier questions. What should the liability be leading to the amount of damage? So to then say that any of those can be addressed by the subsequent question of distribution, in my respectful submission, is
It's probably the case. They have to be determined at trial, so that at the end of the trial process, the sum handed over to the claimant's representatives or a third party is the sum to be distributed, not a sum to be subject to further winnowing down. Or
precisely.
but I mean, it may not really matter. At some stage, the cat has got to do it. But provisionally, I tend to agree with you. It's got to be done at the trial stage rather than the distribution stage, which is after liability has been determined.
It absolutely has to, my lord, and for this very simple reason that if I for a defendant, I will be being overly penalised because I'll have had to pay an aggregate amount of damages by the time of distribution, and I don't then get it back if somehow the distribution only results in some of the actual class member.
It goes to the Justice Foundation.
Exactly. But that means that I, as a defendant, I've been overcompensating, and we know that's not allowed. So that then takes me on, I think, I think I've really dealt with the merits points a little bit out of order. So I stand by those. But it is worth just noting this point, because Mr. Moses, skillfully, I'll grant him, but he made a little bit of a forensic point. He looked at the first instance pleadings in Merrick's and said, oh, look at them. They've got some references to argument about there might be some people who don't have any loss. But of course, that was at first instance, and that was in the context of MasterCard's argument that there had to be individually compensatory amounts leading to an aggregate award of damages that by accumulating individually compensatory amounts, by definition, couldn't be overcompensatory in aggregate because you're adding up individually compensatory amounts. But by the time the appeal came along, life had moved on in the way that life does move on at appeal. So there were only 2 points in the appeal. And the 2 points in the appeal were, number one, the finding that there was not enough data to run the aggregate methodology. And then there was a point about distribution, whether or not that still had to be compensatory. And those 2 points are different to the points that I raise in this appeal, and as does Mr. Jowl. So that's why I say one can't sensibly turn to paragraphs 45 to 47 of Merrick's for the additional reason that the points in dispute here today were not in dispute there. Next point, you're pleased to hear I'm making good progress through these, is that it was said in my learned friend's submission, and indeed I believe perhaps in argument Lord Justice Green made a similar point, that aren't we really for the appellants contending for a much more granular and detailed approach to process? But we say with respect not at all. We just say that process has to be applied to the claim that is actually made and to the whole of that claim upon which the PCR bears the burden. In the case of a top-down aggregate methodology that prima facie includes situations in which there is a real risk of non-liability, as here, the methodology has to be, at certification, it's not onerous, it just has to credibly and plausibly be able to deal with those situations. And I would like to just perhaps show you a passage that we cite in our skeleton, but didn't, from a case that I didn't read out in opening, but it is in the skeleton, and it's the case of Jensen in Canada, and that's to be found at Authorities Bundle 5, my copy of which, maybe it's because it's already open. Yes, it's the one with section 47C in it. So if you were to turn earlier in that, or pick it up again and turn to page 1405, this is a case of the Federal Court in Ontario. And I would invite you to just note that in paragraph 60 of that case, the learned judge said that it is important to emphasise that even though it is a low one, there is still a threshold to be met at the certification stage. And at the bottom of that paragraph, he refers to the Supreme Court of Canada repeatedly reaffirming that the authorisation process, quote, must not be reduced to a mere formality. And then interestingly, at paragraph 62, he explains partly why. He says as follows: I pause to underline that the overarching objectives of judicial economy and access to justice governing class proceedings cannot be considered from the sole perspective of the plaintiffs. True, a key purpose of the certification regime is to facilitate access to the courts of plaintiffs, etc., etc. But the certification process is also there to prevent defendants, even deep-pocketed corporate defendants, from facing groundless suits and being forced to invest significant resources to contest large-scale, time-consuming actions that have no chance of success or do not have the minimal evidentiary groundwork. Stated differently, litigants preventing baseless class actions from monopolising the judicial system to the detriment of other litigants' actions, also part of preserving access to justice for all litigants. So those are eloquently expressed reasons why you shouldn't conduct only a symbolic scrutiny, or you shouldn't allow, in this case, the CAT to have only conducted a symbolic scrutiny.
I think there's another reason which occurred to me, which is that before these proceedings, this action would never have occurred. So defendants are now exposed to what you described as top-down claims, where the total sum, which flows from an abuse, is now recoverable across the entire sector, whereas in the past it would only have been small sums pursued by individual claimants. That's a paradigm shift in the risk for defendants.
Precisely.
Which has never existed before.
Precisely.
Because it's always been bottom line.
And as you will recall from the dissenting judgment of Lord Sales and Legat, they say that that can be particularly burdensome and onerous, and can be used as an instrument of oppression, which it can. Particularly where there's never going to be, as you know, Mr. Jowl will reply on these points, but there's not going to be, we stand by the submissions that there are not going to be coherent or credible, plausible mechanisms for removing the non-liability situation, and he will deal with that. But I just deal with the more, if you like, high-level point that it was suggested an argument that somehow we are suggesting that the actual taking out has to happen at certification. No, 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 with great respect. I tried to make extremely clear in opening that we do not say that the taking out from a top-down methodology of the non-liability or real risk of non-liability situations has to happen at certification. All we say is that the PCR upon whom the burden lies has to arrive at the tribunal and have a credible and plausible methodology for dealing with the fact that there were going to be really likely, as in the generic drugs cases, cases where people didn't in the counterfactual buy, or wouldn't in the counterfactual have bought the overpriced whatever it may be. And that's the problem. You just have to, it's not an onerous hurdle. It's just that it hasn't been met in this case. It could have been, potentially, but it hasn't. And then that's, moving on, it was suggested both this morning and yesterday, I think, by Lord Justice Green to my learned friend Mr Jowl, that is it acceptable to use estimations and assumptions? And that's right when it comes to quantification. But I certainly, for LSER, do not accept that you can do the same by way of estimations and assumptions on the question of liability, the antecedent question of liability. I don't accept that you can use the broad acts for liability. I don't accept that you can guesstimate liability. And I haven't seen a single broad acts case in which that is said, and my learned friend Mr Moser doesn't cite any. So that leaves me with only a few other points, and just picking up some matters from this morning. But briefly, in the 10 minutes that I have, with respect, and I don't want to dwell on this at length, is I contend that the US cases upon which I rely were improperly and unfairly described yesterday by my learned friend. You'll recall that in opening I was running out of time and I didn't read out many passages. But my learned friend said yesterday that he didn't, that somehow my argument was bound up by the same argument in the US cases that concerned Article 3 of the Constitution. And that was a fundamental point of distinction, that those cases rely upon Article 3 of the Constitution and we don't even have a Constitution, let alone Article 3. But that, with respect, is just wrong. The points in the US cases on Article 3 were about standing. It's got nothing to do with the argument of principle upon which I rely, which is to do with the fairness of making people pay for that which they are not liable. And this can be seen extremely clearly in the first of the in Assicol, which is at tab volume 4 of the authorities at tab 33. So this first point that my learned friend made, much to my surprise, can be seen just in the headnote. If you were to turn to page 1143 of tab 33, item 1 of the head notes on the left-hand side, it says the Court of Appeals renews de novo the existing of Article 3 standing required to invoke the jurisdiction of the federal court. It's all to do with standing as between state and federal courts, and one can understand why, because in these competition cases, only some of the states had Illinois brick repealer statutes, and some didn't. And there was a question mark about whether some of the claimants bought in some states and didn't, and it gave rise to issues of standing. That's what it's got nothing at all to do with this case. And then a further extremely surprising submission was made that somehow, or the impression was conveyed, that somehow Nexium and Asacol, on the point upon which I rely them, are like different or opposite, such that Judge Kayata on that point had to get his revenge. I'll come back to that phrase. But that's just not right. They stand, for my purposes, for exactly the same proposition. And that can easily be seen at head note number 4 on page 1144. And it simply reads, a class cannot be certified on the premise that the defendant will not be entitled to litigate its statutory defences to individual claims. That was by the majority. I beg your pardon, that one's Asacol, but in Nexium, if one were to turn to tab 30, sorry, I got the cases slightly out of order there. It says exactly the same thing. If you pick up head note 8 on page 1081, it says the same thing. Defendants cannot be held liable for damages beyond injury caused. Well, as you know, that's my submission. And head note 10, at class certification stage, court must be satisfied that prior to judgment it will be possible to establish mechanism for distinguishing injured from uninjured class members. So in fact, the cases, both Court of Appeals cases in the First Circuit, both stand for exactly the same proposition. There's no question of getting your revenge, not leaving aside that I don't recognise that epithet at all. There was a difference of opinion between Judge Kayata in the first case and the constitution of the court in the second, but it went to a much more detailed and granular question about the use of affidavits and rebuttable presumptions. That's got nothing to do with my case. With respect, I don't mind what they dissented about on that. In short, they both stand for the proposition that you have to have a way of winnowing out over liability, and that way must be discernible at the certification stage. And interestingly, I would invite you to read all of the highlighted passages in Asacol, as I said before, but one that I must read out now is the one on page 1157 and the bottom right-hand side of Asacol. This is in Judge Kayata's judgment. So he refers to different procedural ways of dealing with this in other circuits, and that's important because my learned friend sought to convey the impression that there were different substantive outcomes, but all that the previous page does is it says there are different procedural ways of dealing with this, whether you use the standing point or whether you use Rule 23. But most importantly, he says at the bottom of 1157 on the right, in any event, in no case cited above, no case, nor in any case to which the plaintiffs have directed our attention has a federal court affirmed a damages judgment in a class action against a defendant who was precluded from raising genuine challenges at trial to the assertion of liability by individual members of the class that was known to have members who could not be presumed to be injured. Not a single case. And Mr. Moser hasn't produced a single such case. So I, in summary, do not accept that there was anything resembling a fair treatment of those cases. And in fact, if you were to reject my submissions, I accept they're only at best persuasive. But on this point, of that low bar, just simply showing that you can later extract the problem areas, that's all you have to do, then in fact you'd be making the regime that much more encouraging of claimant class actions than even in the States. But as we know from the materials in the bundle, for example, I don't need you to turn it up, but in tab 6 of the authorities at 1603, which is in none other than Professor Mulheron's article, she says there's an irony to this, however. The hesitancy to introduce US-style class actions was a mantra throughout the long lead into the UK competition law class action. So far from not wanting to encourage this class action claimant style ambulance chasing litigation culture, if you were to reject this low hurdle that the Court of Appeals in the First Circuit has set out, then you would be doing exactly that. That leaves me with one final, if you like, set of points on things my learned friend said this morning. I'll take the second one first because it's short. We don't resile from what Mr Backway says in paragraph 73 to 77 of his statement about how it not being an agency relationship. That was the clear evidence before the tribunal on my appeal. It wasn't controverted, it wasn't capable of being controverted, and that's an answer to my learned friend's primary point that he said was this is a case of agency. He now shifts ground. For the first time ever, I heard about 45 minutes ago that this is now somehow a case of collective dominance. Well, that's not pleaded. Collective dominance, that somehow it's not that I could, my own TOC could have forced the third party.
Remember those words, collective.
No, but that's tantamount, because what he was saying, tantamount to that, because what he was saying was, oh, well, I can see how the evidence says that a top couldn't individually force a given third party retailer to sell a fare in a certain way. But look, they carefully used the word individual. In fact, that was in my learned friend's evidence, not mine. But be that as it may, the corollary of that is he was saying, oh, well, collectively they can do it. He did say collectively. Collectively they can do it. But that's not it. That's a completely different case. That's not.
Right, I understood it to be that collective licensing through, was it, I forget, was it RDG or whatever
Yes,
the name of the, as opposed to individual licensing.
Yes.
I understood it to be that because of the collective arrangement that precluded contractually individual licensing.
But
That's all I'd understood.
But that's the critical point, my lord, because the collective, it's shifted now from being an allegation that I have abused my alleged position of dominance by me failing or doing something, either doing or failing to do something as regards a third party retailer, to becoming collectively I could or should. And that's critical. That's a completely different case. The law on it is completely different. It's not pleaded. It's the first time I heard it 45 minutes ago. And that's not a sustainable response to my strikeout that was based upon uncontradicted evidence on the point that I do not resile from.
That's another pleading that you're in a cartel.
Well, again, it's not pleaded that somehow the rail delivery
I
group
haven't
agreement is
understood
an
that. I
anti-competitive.
understood that to be, as it were, a factual clarification about licensing, but I see your point.
There we go.
Yeah.
And then that leaves me only with one final issue that I'll take very briefly. And I know Mr. Jarrell is going to deal with this in part. The problems with my learned friend keeping on saying, don't worry, I can take these things out. They all focus on the wrong question. In every single instance, he's talking about looking at actual data from the actual world and saying, I will do this with it and estimate that with it and adjust it in this way, and then I'll use that to take it out. It's the wrong question. He always has to, Mr. Holt always has to ask himself what would have happened in the counterfactual world. If, in the counterfactual world, the customer in question on the given transaction in question at a given railway station on a given day would not have bought a boundary fare, but instead would have bought another one, that's the situation for which my client is not liable. But he never even asks himself that question. He only says, look at the actual data. He should be looking at the counterfactual data, and that's what leads to all the problems with the survey. The survey couldn't conceivably, no matter where it's advanced, couldn't conceivably in any credible and plausible sense, and this has always been our point, say, how am I going to find out what Mr. Jones would have done on Waterloo platform in December 2015 when on that particular day he might have been in a hurry or being reimbursed or forgotten his travel card. That is not amenable to any kind of survey. And Mr. Zhao is going to develop why what is said about the survey doesn't fit the bill. So unless I can assist further, those are my reply submissions. Thank you.
My lady, my lords, may I start with a specific point to correct a misapprehension that my learned friend has encouraged about the potential counterfactual selling arrangements. By way of background, my learned friend showed you, again, paragraphs 23 and 24 of Mr. Cameron's statement, which do show that boundary fares are available from the vast majority of first MTR's ATMs, and indeed a majority of all relevant ATMs where tickets for the relevant area are on sale. And so my learned friend's proposition in the counterfactual is that they should have been more easily available. Now, quite how they should have been made more easily available has not been perfectly crystallized in my learned friend's pleading. But the claimants have put forward the alluring proposition, has been effectively floated, that the ATMs could the TVMs rather, could be reformatted so that all passengers buying tickets would simply have a window pop up, and they would say, "Do you have a travel card?" You would click it, and hey presto, you would have a cheaper ticket. Now, website design or redesign is a complex business, and that is simply not a possibility in this case. And the reasons are as follows. First of all, one has to be absolutely clear. A travel card is not a rail card, nor is it like a rail card. It is a ticket that gives you an unlimited travel within a particular zone for a particular time. So a boundary fare is not a discounted fare like a rail card fare. A boundary fare is a ticket that it gives you, instead of the origin station, the ticket states that you go from a zone boundary. So a TVM can't give a discount to a ticket as if for somebody who has a travel card. Instead, what it has to do is to suggest a different ticket with a different origin. And depending on the person's circumstances, that might or might not be the cheapest fare. Now, as to this idea that it would be possible simply to put in the fact that you had a travel card, and that would be, then it would, hey presto, out would come the appropriate fare. That's not correct. I mean, my Lord, the Chancellor, noted already that you would first of all have to put in the zones for that travel card. But it goes beyond that. And if I may show you, there are many different types of travel card. And if I could take you to the supplemental bundle at page 263, please, where you see in the evidence the different types of travel card are set out.
Supplementary
Bundle 1, page 263. And you see at paragraph 42, it explains that there are currently two broad categories of travel cards, the in-boundary travel cards and the out-of-boundary, and three subcategories within each. I don't need to go through them all, but they all apply not just to different zones, but they are all valid at different times of day and on different days. So it's not just enough to say, even I have a travel card and these are the zones. You have to stipulate what is the type of travel card. And then, of course, added to that, you have what is the period for which the particular travel card.
Attention please, attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Do not use the lifts. Attention please, attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Do not use the lifts. Attention please, attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Do not use the lifts. Attention please, attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Do not use the lifts. Attention please, attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Do not use the lifts. Attention please. Attention please. A fire has been reported in the building.
How much longer do you need,
Please
Mr.
leave the
Judge?
building immediately by the nearest exit.
15
Do
minutes.
not
please.
use the lifts.
15 minutes?
Yes.
Can we say quarter to two?
It's fine with me, just come back whenever it's.
Attention please. Attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Do not use the lifts.
Quarter to two. Quarter to two?
Quarter to two?
Oh, thank you.
Attention please. Attention please. A fire has been reported in the building. Please